This is a summary of the Supreme Court's judgment in Sanambar and the Secretary of State for the Home Department. This appeal concerns the effect of the European Convention on Human Rights on decisions to deport foreign nationals who lawfully settled in the United Kingdom as children and were subsequently convicted of serious criminal offences. The appellant is a national of Iran. He was born in 1995. He arrived in the United Kingdom with his mother in 2005, having been given indefinite leave to remain. He has a particularly strong bond with his mother, with whom he has lived all his life. He has no family ties with Iran, although he speaks Farsi with his mother. Between 2009 and 2013, the appellant was convicted of 3 counts of attempted robbery in 2009, possession of an offensive weapon in 2011, and 6 counts of robbery, 3 counts of attempted robbery, and 1 count of handling stolen property in 2013. The 2013 robberies were all committed at night and at knife point. The victims were aged between 15 and 18. In the light of his 2013 convictions, for which the appellant was sentenced to 3 years detention in a young offenders institution, the Secretary of State decided that the appellant's deportation would be conducive to the public good and would not be in breach of his Article 8 right to respect for his private and family life. She made a deportation order in respect of him. The appellant appealed that decision. Following a rehearing before the Upper Tribunal, his appeal was dismissed. The Upper Tribunal held that the appellant had not met the threshold under the immigration rules for resisting his removal, essentially because he had failed to show that there were significant obstacles to his integration in Iran. A further appeal by the appellant to the Court of Appeal was dismissed. The Supreme Court unanimously dismisses the appeal for the reasons set out in a judgment given by myself, with which all the other members of the Court agree and which I will briefly summarise. The appellant, who entered the United Kingdom lawfully with leave to remain, is a settled migrant. According to an established line of European Court of Human Rights Authority concerning the deportation of settled migrants who have lawfully entered the host country as children, national authorities have a margin of appreciation in deciding whether the interference with their Article 8 rights is necessary in a democratic society and proportionate to the legitimate aim pursued. That margin can be exercised by Parliament, by the Executive through the rules, or by judicial decision, but is subject to European supervision. Those authorities also established that in striking the balance in such cases between a settled migrant's rights under Article 8 and the prevention of crime, the court should consider criteria set out in Unner and the Netherlands. Subsequently, in Maslow v. Austria, the European Court of Human Rights held that where a settled migrant had lawfully spent all or the major part of his childhood and youth in the host country, very serious reasons were required to justify expulsion, particularly where the person committed the offences underlying the decision to deport as a juvenile. The Supreme Court rejects the appellant's argument that in a case involving a settled migrant who has lawfully spent all or the major part of his childhood in the host country, the court must separately consider whether there were very serious reasons to justify expulsion as a further condition after the examination of the Unner criteria. Rather, the authorities established that the court must carry out a delicate and holistic assessment of all the criteria flowing from the European Court case law in order to justify the expulsion of a settled migrant such as the appellant, who has lived almost all of his life in the host country. It must be demonstrated that the interference with his private family life was supported by relevant and sufficient reasons. Here, the Upper Tribunal gave careful consideration to the particular circumstances of the appellant's situation. It also considered the nature and seriousness of the offences, the background of previous offending, and the continuing risks of reoffending despite the rehabilitative measures the appellant had undergone in custody. There was ample material to justify the Upper Tribunal's conclusion that the obstacles to the appellant's integration in Iraq were not very significant. Accordingly, the Upper Tribunal was entitled to conclude that the deportation of the appellant would not be disproportionate or that there were very compelling reasons to prevent it. Thank you for your attention.